Okay, can you see me as well?
Yes.
Okay,
Yes.
because I
And we
can't
can
see
hear
you,
you.
but maybe that will help me
Okay.
making the presentation better.
Okay.
So anyway, let me for starts introduce myself. My name is David Adesola BANKOLE, and I am a PhD student at the Faculty of Law, actually a PhD candidate at the Faculty of Law of the University of Zagreb, and I have the honor and opportunity today to speak to you about maintaining personal relations, or you can also say contacts with a child, and this all will be presented in the light of the case law of the European Court of Human Rights. I apologize for the slight difference in the title of the topic I prepared today, because it is a bit different than the one I initially proposed, but after holding consultation with Professor Korach-Grauwacz, who was kind enough to help me to prepare this presentation, who I would like to thank for the time she invested to make this presentation better as well. We decided to change the topic, as maintaining personal relations and maintaining contacts are both terms which are used in the Croatian legal system, and I believe in the legal systems throughout Europe. And the terms are quite similar, but not necessarily the same. Maintaining personal relations is a term which is used in the Croatian Family Act, but is also known as the Croatian legal system because the Convention of Contacts with Children translated uses the term contacts. Both of those actually terms in their essence mean much more than just basic contacts. They mean the right actually to have the family members to enjoy each other's company, to have prolonged times of prolonged encounters where they're actually together, and also it extends to other participants or the adressates, which are not necessarily the child and the parent, but also brothers, sisters, grandparents, or some other people who are close to the child. Also means the rights to correspondence with the child, to know personal stuff and information about the child. So the topic is quite composed and too big, and we'll be more specifically talking actually about the right of a child and the right of a parent to be in contact or to maintain contacts and the right of the child to maintain contact with the parent who she is not living with, or the parent who is not living with the child has the right to maintain contact with them. And even more specifically, we'll be talking about a Rebic group of cases, which represent a group of cases which was heard before the European Court of Human Rights at the period of 2015 up until now, in those four cases are Rebic against Croatia, Kabe against Croatia, Begovic against Croatia, and Jurisic against Croatia. Unfortunately, for Croatia and for the applicants in those cases, in all four of those cases, the European Court of Human Rights found a violation of Article 8 of the Convention for the Protection of Human Rights and Fundamental Freedoms, and the violation was actually the failure of national authorities to enforce a parent's right to maintain a regular contact with his child.
Sorry, Mr. Bankole, I don't want to interrupt you,
yes.
but we can see your first slide.
So the second slide didn't. I said it should be. And now.
Oh, it is still the first one.
Only the first one.
Now it is the second. Okay.
Is it the second now?
Yes, it is the second now.
Okay, let me try. I'm sorry.
No problem.
Yeah. So this is the first one, I believe. The first slide. And now is the second.
Now.
Now is the second.
Yes.
Okay. Is it now the third, or is it still the second?
Yes.
Okay, now let me go back to the second. I'm very sorry. I hope everything will be okay up until now. But I did everything as the instructions told me. But that's another issue. I stopped at the point where I was talking that actually the significance of the problem is huge, even if you just consider that it's four cases, in which you can imagine what horrible implications that has to a child not be able to be in contact with his parent, and horrible implications for the parent who is not able to see his child for a sustained period of time. In some of these cases, we are talking about, like, Mr. Rebic saw his son 3 times before he came of age, even though he initiated multiple procedures to ensure his right to regular contact with his child. But as said, only if we don't look only at the significance in that, the significance of the case also comes from the fact that 8 to 10% to all of cases considering contact rights are disputable, and there's like a lack of cooperation between the parents, and the potential of the number of cases to rise in this issue is quite big, and we hope that the legislative changes that have been made in Croatia will actually help to bring an end to such a bad practice current thesis. But before we go to the facts of the Ribic group of cases, I would like to use the opportunity to at least short notice try to explain how does Article 8 function and what it is. I was free enough to copy paste Article 8 of the convention at the beginning of this slide, and you can see I bolded certain words that are important for us, as Article 8 doesn't only regulate family life, it also regulates the respect for private life, the respect for a home and correspondence, but what is most interesting for us is family life. When we think about family life, most of us understand this as a self-explanatory concept, but and even though it does represent private life and family matters, it basically, in terms of at least of the European Convention on Human Rights, is an autonomous concept, as the European Court of Human Rights is the only body who is allowed to actually interpret this concept, and this concept is independent on all the other definitions one might find in other legislative systems throughout Europe or throughout the world. Therefore, it has a certain content which, as the convention is a living instrument which also evolves with time, and actually is basically growing in a bigger body of work and rights which are protected by this concept. But you can also see that in not only family life, I have also bolded the word respect. And if you look at the wording of the second paragraph of Article 8, you'll see that it starts with there should be no interference, which means that initially this, or at least when it was written and when you read the article, the first that comes to mind is that actually there are actually negative obligations to the state prescribed by this article, which state that the state shouldn't interfere. It shouldn't do something to harm people's right family life or right private life. But the word respect was in the case law of the European Court of Human Rights interpreted that the state also has positive obligations. It means that in family matters, at least, the right to respect for family life means an obligation of the state to enable all persons who make up a family to lead a normal family life and the normal development of family ties. This was established in one of the landmark cases of the European Court of Human Rights, and basically, the first time the court ever stated the need for positive obligations was in Article 8. Now you can find throughout other articles of the convention as well, and basically, positive obligations mean that the state has the obligation to pass certain legislation, to ensure certain procedural rights, to educate people about to protect individuals, not only vertically from the state, but also horizontally from other people who might interfere in their rights. But in talking about cases of family care cases and custody cases, the positive obligation is a mutual, actually state must provide as a positive obligation, a mutual enjoyment by parents and child of each other's company, as it constitutes a fundamental element of family life within the meaning of Article 8 of the Convention. And now, having that in mind, we can maybe go further to the factual state in the cases I cited before. But as we are quite short on time, we'll just analyze the factual case in Ribic versus Croatia, which is the landmark case, and actually it will be quite good to represent the problems and the issues applicants had in Croatia in their strive to actually maintain contacts with the children. As I said, what the court actually indicated here or found violation was failure of authorities to enforce a parent's right to maintain a regular contact with his child. And when these cases happened, the Family Act of 98 and free as it was enforced, then obviously the whole procedure was basically legislated through it. And going to the facts, you see that in 1993, the parents separated. Mr. Rebic separated from his then wife, and she moved out of the household with the child who was 2 months old at the time. The proceeding seeking divorce, custody, and maintenance was actually initiated first in 1996. And the first decision, which is just an interim measure, which was passed by the Social Welfare Center, was passed in 2003. So it's like 10 years has passed since the applicant had any right, any formal right to received any formal decision which would allow him to see his son. This incision, or actually this interim measure, was never executed, and he had to wait until 2005 for him to receive a final decision by the courts on contact rights. Again, the mother, because there was a lack of cooperation and a lot of dispute between the parents, the mother decided not to follow the final decision and didn't want to abide by it. So he had to start multiple enforcement proceedings, of which none were actually successful. And then in 2013, the second enforcement proceedings were suspended because the child turned 18 in 2011. So, I mean, just this last sentence can probably implicate you or show you how slow the system actually worked at the time when actually a pressing need was supposed to be applied. Also, multiple criminal proceedings were instigated and started against the mother of the child, but even though she got criminally convicted, nothing of that helped Mr. Rebic to see his son, which eventually, when you look all the facts together in 18 years, how long this procedure lasted, or even longer, Mr. Rebic saw his son only 2 or 3 times in this whole period, even though he started multiple procedures. And the facts are basically the same as I said in all the other cases. And then, but when we try to analyze them as a group of cases, we can see that in all of those cases, the European Court of Human Rights tried actually, as them when analyzing them, asked itself the two same questions. The first one: did the delays in the decision-making procedures, the deciding on contact rights, did lead to de facto decision-making in cases? At the first question, the European Court of Human Rights actually, unfortunately for Croatia and unfortunately for those applicants, identified that it really did. The delays which happening in the decision-making eventually led to de facto decision making, because so much time has passed between the separation of the child and the parent that at the end the alienation between the two of them was so big that no other decision could have been made except the one that was made forcefully or by the will of the other parent, and that is not to see, because the child grew so apart from his other parent, he decided not to see him. He often had this problem of loyalty conflict, which also makes the thing even more complicated. So the delays were a major issue. And then the second question the European Court always analyzes is: have the authorities of the Republic of Croatia in this certain group of cases made the measures that can be reasonably required of them in these circumstances in order to exercise the parent's contact rights with the child? From the wording of this question, you can see that the measures that were expected from Republic of Croatia was not the measures of results, but actually the measures of means, which means that the European Court of Human Rights understand that Croatia is not a miracle maker. He cannot make things happen if all parties are completely unopposed. But still, having that in mind, positive obligations and principles indicate or actually request from Croatia to take measures, maximum measures, to reconnect parents with their children and to facilitate such connection. These positive obligations also implicates that even in cases in which children explicitly refuse to have contact with their parents due to the loyalty conflict, the state has to the state has to come to the bottom issue. Why is this happening? And try to resolve that issue. Try to find a venue where the contacts and between the child and the parent can at least start, if not perfect, just to start, to have some kind, because that is eventually in the best interest of the child. And also the state cannot excuse itself that there was a horrible lack of cooperation between the parents, as that is, as we said, in most of these cases which end up at such a high level is self-inflicted. It always happens, and the state has to find a way to work around it and to try to get to the bottom of it. And obviously, in all of these cases, you cannot overstate the importance of acting urgently. As time passes, people grow apart, children grow apart from their parents, and when this, even for instance in the Kabe case, it was just a summer holiday where the children spent with their father, and after the summer holiday, which lasted like 2 months, the children didn't want to come back to live with their mother, even though the court ruled in that way. And there was no way, do all efforts that lady tried, the applicant tried in case didn't lead to any success. So acting urgently in these cases, or not acting at the proper time, it means like you're not ensuring those people the rights that they're guaranteed. But obviously each judgment has its implications, and there are certain obligations which come throughout, which come throughout this decision that the European Court of Human Rights makes. And pursuant to Article 46 of the Convention, the respondent state's obligation is to abide by the final judgment of the court in which they are a party. Those obligations entail the payment of reparation or actually compensation, and it also sometimes means the adoption of authorities of the respondent state of individual measures, which should serve as a restitutio in integrum in these cases, and general measures which should actually prevent similar relations in the future. Looking at awards that compensation that were awarded to the applicants in the Ribic group of cases, we can see that they range from €0 to 25,000 euros. Mr. Ribic received the most, since, as I said, he only saw his son 3 times in the period of 18 years. But I don't believe that 25,000 euros actually can amend the damage that he has actually suffered and the relationship has suffered. Mr. Begovic, on the other hand, didn't receive any compensation because he didn't request any, and the European Court of Human Rights doesn't actually give compensation if you ex officio, if you don't request it. No individual measures were indicated. Even though, for instance, in the Kabe case, they were requested, but the court didn't find it necessary since the procedure was still ongoing and there were some signs that they might come to resolvement of these issues, and that the state is aware of its positive obligations, which it has to do. But just looking at the individual measures and the compensation which was awarded, you can see that the actions taken before the European Court of Human Rights have a certain feel of more of an actual popularity, because it doesn't help, at least not in these family matter cases, it doesn't help resolve these issues, but can be a stepping stone for future actually cases and for future jurisdiction. In that sense, the general measures in the Republic of Croatia and was the new Family Act of 2015. As you can see, I don't want to go through all of these bullet points, because they represent parts of the law, parts of the act and legislation, which we believe now and hope can bring to a better situation and to better to the better protection of contact rights between children and parents. In essence, what has happened? The right to maintain personal relationship, or a right to maintain contacts, was elevated from just a right to a principle. Now there's a whole head in the act which is dedicated to this issue. Obviously, the Strasbourg Key and the Convention on the Contact with Children had a big influence in the changes of the Family Act, and also we can see that the Constitutional Court of Croatia has adopted the Strasbourg Key, and we can see that even though such problems are still happening in Croatia, we have the possibility of actually keeping them in the national level and giving the parents and the children the protection they can need at the constitutional court. That would be all from me, and I would like to thank you for your time. I hope I have not overstepped my time limit too much.